Sir, I present the appeal against the judgment passed by the trial court Chhatarpur MP in the matter of Ramesh Kumar and others versus State of MP. To the Honorable Judges of High Court, humble appeal of the appellant. The appellant above named submit as follows. The present appeal arises out of impugned judgment dated 10 February 2025 passed by the trial court Chhatarpur MP, whereby trial court ordered the conviction and sentence concurrently, rigorous imprisonment for 7 years or 5 years. The appellant have filed the present appeal by way of special leave challenging the finding of the trial court. In the brief case of prosecution is that the deceased and accused appellant number 1 were married on 9 November 2023 on 31/7/2024 at about 4 or 4:30 p.m. Some person informed the complainant that his daughter was alive and admitted in the hospital. On this information, he along with his wife and son reached the hospital and found that the deceased passed away due to burn injuries. The prosecution case was that the deceased committed suicide by setting herself ablaze just after 1 year of her marriage, and that soon before her death, she was subjected to cruelty and harassment on account of bringing less dowry by the accused and their parents. The appellants were convicted by the trial court, sentenced to undergo rigorous imprisonment for 7 years for the offence punishable under Section 80 of Bharatiya Nyaya Sanhita 2023 and undergo rigorous imprisonment for 5 years for the offence punishable under Section 108 of Bharatiya Nyaya Sanhita 2023, which deals with avertment of suicide. So it is a matter of grave concern that often trial courts record the statement of an accused under Section 351 of Bharatiya Nyaya Suraksha Sanhita 2023 in very casual and cursory manner, without specifically questioning the accused as to his defense. It ought to be noted that examination of an accused under Section 351 of BNSS cannot be treated as a mere procedural formality, as it is based on the fundamental principle of fairness. This provision incorporates the valuable principle of natural justice as odi ultrum partem, as it enables the accused to offer an explanation for the incrimination material appearing against him. Coming to the issue of dowry demand, the prosecution have no evidence on record that showed death caused due to demand of dowry or cruelty. Sir, in this reference, appellant have records of doctors in which that shows the mental condition of deceased, which is unstable due to some medical condition. For that reason, she get too depressed, and before this death, she tried attempt to suicide for 2 to 3 times. But their lost family saves him. Related to this incident, appellant called to their parents, but they gave no answer. After 3 to 4 days, appellant get back to their wife in their maternal house and told to their family related to his mental condition. But again, his family members dropped him off at his in-laws' house and said that his health is fine now. But in 31/7/2024, when appellant parents and appellant was not in their home, then after some time, his husband come back to home and saw that deceased was burned. Then appellant and his neighbor took him to the hospital, and then they found that she was died. In all above incident, appellant parents were out of city. So in this point, they are not involved in this incident, and in this they have evidence related to their absence, that is traveling tickets. So in this point, I would like to quote recently judgment of Supreme Court of India in case of Barao versus State of Telangana 2018. It was observed by the Supreme Court of India that the court should be careful in proceeding against the distant relatives in crimes pertaining to matrimonial disputes and dowry rates. The relatives of husband should not be roped in on the basis of omnibus allegations unless specific instances of their involvement in the crime are made out. And in another ruling of Supreme Court of in case Kehkasha Kaushal @Sonam and others versus State of Bihar 2022, the Honorable Supreme Court held that In the light of relevant circumstances, if no specific role has been attributed to the accused, then it would be unjust if the accused is forced to go to the termination of trial and practice of making the relative of husband to undergo trial on the basis of general and omnibus allegation. Must be discouraged. Allowing prosecution in absence of clear allegation against relative of husband would simply resulted in abuse of process of law. Sir, in all of the above pointers, which clearly shows that there is no any involvement of appellant and the parents, and the prosecution have no specific evidence which shows the connection of death, which appellant and all allegations which are made against the appellant is omnibus in nature, and they have no direct evidence to prove it. Therefore, I requested to court, upon consideration of the relevant circumstances and in absence of any specific role attributed to the accused, so for the interest of justice, appellant and his parents should be honorably acquitted of the false accusation which was made by the deceased family members, and also cautious conviction and false FIR.
Sir, appeal was filed by the appellant on 13th of February 2025 against the judgment of trial court in case of Ramesh Kumar and others versus State of Madhya Pradesh. Sir, I am replying to the appeal on behalf of the respondent. For the sake of brevity and convenience of the Honorable Court, I summarize the fact of the case. The deceased and accused, that is appellant number 1, were married on 9th of September 2023. On 31st of July 2024 at about 4 or 4:30 p.m., some person informed the complainant that his daughter was ailing and admitted in the hospital. On this information, he along with his wife and his son reached the hospital, where he found that his daughter had passed away due to 85% blood injuries. Complainant Ghanshyam Das suspected that his daughter had passed away due to cruelty and harass for dowry and abatement by her in-laws. So, the deceased father went to the police station and lodged FIR against deceased husband and his parents. After police investigation charges were framed against accused in final report under section 80 and 108 of Bharatiya Nyaya Sanhita 2023. And after hearing all evidences and witnesses, the trial court convicted the accused and sentenced them to 7 years and 5 years rigorous imprisonment, consequently under section 80 and 108 of Bharatiya Nyaya Sanhita 2023. And this judgment is questioned by the appellant in appeal. And sir, the contention of the appellant that the statement recorded under section 351 of Bharatiya Nagrik Suraksha Sanhita by the trial court were held in a very casual and cursory manner is totally wrong, because according to section 351 clause 1 subclause B of Bharatiya Nagrik Suraksha Sanhita, it is mandatory for the trial court that to ask direct questions to the accused and allow the accused to explain his case. So, the procedure of section 351 was properly followed by the trial court, and that time the prosecution and defense counsel were present there to assist the court in recording the statement. The contention of appellant that no evidence was produced by the prosecution in trial regarding dowry demand and cruelty is wrong, because the appellant harassed deceased for several times since marriage for giving less dowry than demand. The deceased used to inform her parents through telephone, and this was accepted by prosecution witness 1, that is father of the deceased, in his statement. And in this regard, deceased also had a WhatsApp chat with her brother, the printout of which was produced as evidence, that is Exhibit P1 in the court. The appellant also beat up the deceased several times regarding the demand of dowry, and due to which once the body of the deceased was badly injured, in relation to which the doctor's medical report was produced as evidence, that is Exhibit P2. The prosecution witness 2, that is brother of the deceased, stated in his statement that on several occasions when he had gone to meet his sister at her in-laws' house, the deceased had told him that she was harassed for dowry, demand and scooter. The allegation of the appellant that deceased was suffering from mental illness is wrong, because the the deceased had also earlier tried to commit suicide due to repeated harassment and abatement by the appellant, but she was stopped for doing this after being convinced by her parents. The appellant contention that he had left the deceased at her maternal home due to her mental illness is wrong, because after marriage the deceased had come to her maternal home only for the ritual of Pagfera, which was held after 2 days of marriage, and after this the appellant never brought the deceased to her maternal home. The absence of the appellant at home on the day of the deceased suicide is not an excuse, because for abatement of suicide it is not necessary that the abatement should happen immediately. The abatement can be done a few days earlier as well, which was done by the appellant, and due to which the deceased committed suicide on 31st of July 2024 by pouring kerosene on herself and set ablaze on herself and died. So two questions have arisen for decision before High Court. The first is whether the trial court was right in convicting the accused on the charge under section 80, and second is whether the trial court was correct in convicting the accused on the charge under section 108 of Bharatiya Nyaya Sanhita. So let me tell you one by one why they found the accused guilty under section 80 and 108 of Bharatiya Nyaya Sanhita. So accused is convicted in section 80 because the facts and circumstances of the case fulfill all the essentials of section 80, which are: deceased was subjected to cruelty and harassment for dowry before death. Second is deceased died due to burning. Deceased death occurred within 7 years of her marriage. And accused is convicted by trial court under section 80 because accused had abated deceased to commit suicide for several times. And under section 117 and 118 of Bharatiya Sakshya Adhiniyam, the court shall presume that the death of the woman was due to harassment for dowry demand, hence the trial court convicting the accused. Sir, there are some Supreme Court rulings related to section 80 and 108 of Bharatiya Nyaya Sanhita. The first is Bachni Devi versus State of Haryana 2011. The appeal was made to the Supreme Court. The apex court held that demand for any property or valuable security having nexus with marriage constitute dowry demand. The cause demand is immaterial. It observed that the deceased was harassed by the accused after her father denied fulfilling the demand. Hence, the harassment deriving the deceased to commit suicide in dowry death. Accordingly, the appeal was rejected by the Supreme Court and the 2 months imprisonment was given to accused and surrender for going through the imprisonment conferred to her. In case of Major Singh versus State of Punjab 2015, a 3 judges bench of Supreme Court held as follows to sustain the conviction under section 80 of Bharatiya Nyaya Sanhita. The following essential ingredients are to be established. The first is the death of the woman should be caused by burn or otherwise than under abnormal circumstances. Second, such death should have occurred within 7 years of her marriage. Third is she must have subjected to cruelty or harassment by her husband or any relative of her husband. Fourth is such cruelty or harassment should be in connection with demand of dowry, and such cruelty or harassment is shown to have been meted out to the woman soon before her death. In case of Satvir Singh and another versus State of Haryana 2021, the Supreme Court observed that phrase soon before death cannot mean immediately before. The bench before observed that a close and live link between the dowry death and cruelty or harassment by the husband and his relative must exist. The above observations were made while the bench was rejecting the appeal filed by the accused convicted for the offence under section 80. Therefore, after all the arguments and evidences, it is requested to the court to uphold the decision of the trial court and the appeal of the appellant should be rejected. Dowry demand is a serious issue in the country. Hence, the accused should get the harshest punishment in the offence.
Sir, after considering the argument presented from the side in reference to contention related to dowry death and other allegations related to abatement to suicide, I would like to address certain point as presented by respondent, they are as follows. Sir, in this, respondent fails to show proximate link between the death of deceased caused by cruelty or dowry demand. And as earlier, I mentioned that they have not given any evidence which arises the link between the death of deceased. And the second question arises in the point of presumption under section 118 of Bharatiya Sakshya Adhiniyam 2023, which specifically deals with situation where a woman dies within a short time of marriage and there is evidence of dowry related harassment or cruelty before her death. So here, respondent fails to prove that dowry death of deceased committed soon before her death and she had been subjected by cruelty or harassment in connection with any demand for dowry. Dowry presumption under section 118 of Bharatiya Sakshya Adhiniyam 2023 can be rebuttable by evidence, by which appellant presented evidence which clearly proves that there is no connection of death related to dowry or harassment. Sir, for the interest of justice, I humbly request to court that appellant and his parent should be honorably acquitted and also be quashed his conviction and false FIR which was made against appellant.